As a prosecutor, you have the burden of proof. Your opportunity to meet that burden is through direct examination of your witnesses. In this video, I'm going to walk you through step by step how to prepare and how to conduct your next direct examination. Coming up. What's up, everybody? I'm attorney Eric Scramlin with Tactical Legal Solutions. I've been a prosecutor almost my entire career, and I still remember how terrifying it was preparing for my first jury trial when you look at the task of getting everything ready and how daunting it seemed. What I found over the years, now that I've done several jury trials, is that you need to break the process down into small steps. In this video, I'm going to talk about the very important step of direct examination. Direct examination is the heart of your case. As a prosecutor, this is your opportunity to present your witnesses, to tell your story to the jury, to elicit evidence to support your story. You set forth your theme and your theory, and you lay foundation for exhibits. In this video, we're going to cover the role direct examination plays in a prosecutor's case, some of the rules that apply to direct exam, and finally, a method that's worked for me over the years in organizing and conducting a direct examination. So let's talk about the role of direct examination in a prosecutor's case. First and foremost, direct examination is the heart of your case. As the prosecutor, you get one shot and one shot only to establish your evidence. If you don't elicit the evidence and you don't meet each and every element beyond a reasonable doubt, then you don't survive directed verdict. But anybody can get up there and have your witnesses testify to the elements of your case. The true art of direct examination as a prosecutor is your ability, through your witnesses in direct examination, to tell the story of the case, to tell your theory to the jury. And obviously, direct examination is your opportunity as the prosecutor to admit evidence, to lay foundation for exhibits, to get those things in front of the jury. But again, going back to number two, make sure you do it in a way that tells a story, that's persuasive, that sticks with your theory of the case. Before you sit down and put pen to paper and start scripting your direct examinations, I typically sit down and focus on these 5 goals. The number one goal is to make sure that you're establishing your theory through your witnesses. Again, your theory is the what happened, why did it happen, and why does that mean the jury should convict. You should be scripting your direct examination so that each one of your witnesses are contributing to your theory and to your story. The second goal is to make sure you establish the facts. Now, we've already talked about this. As the prosecutor, you have the burden of proof. So you need to make sure that your witnesses are establishing the facts that you need to meet your elements. However, in doing so, I like to focus heavily on the undisputed facts, facts that are not going to be in dispute from the defense, and then use those to enhance my theory and my story. After I've accomplished that, then I will try to elicit things that make the likelihood of some of the disputed facts more likely. I'll give you an example in a DWI case. If I have a breath card, it's likely that defense isn't going to dispute that. They don't have an expert on their witness list. So I'm going to focus on that breath card and have that meet with my theory that the defendant was clearly intoxicated because he's over the legal limit. However, the defense is challenging that the defendant was the driver because, let's say in this case, it was like a single car accident. Police arrive and he's standing outside the vehicle. So when I establish my undisputed facts with the breath card, I'm then going to try to elicit testimony through my direct examination that make it more likely that the defendant was the driver of that vehicle. So the next goal is to make sure that you're laying the proper foundation for the admission of evidence and make sure that you're admitting evidence through the proper witness. So as you script out your direct examinations, don't forget, especially if you're a younger prosecutor, you're not used to the procedure of laying that foundation, script it out step by step, each question that you have to ask to make sure that you get that piece of evidence admitted. And also don't forget to lay the foundation now. For example, if you have a crime scene tech on the stand who found a piece of evidence on the scene, like drugs or shell casing, and then tagged it and bagged it, and then it was sent to the lab for testing, you're not going to admit that piece of evidence till the lab analyst testifies, but you need to lay the foundation with the crime scene tech. The next goal I call highlighting the credibility of your witnesses and drawing the sting. Now, as a prosecutor, you're not allowed to vouch for your witnesses' credibility, and I'm certainly not condoning doing anything like that. However, The credibility of your witnesses is essential for proving your case. If the jury doesn't believe or doesn't like your witnesses, then they're not going to return a guilty verdict. One of the things you learn very quickly as a prosecutor is that you oftentimes have witnesses with credibility issues. So you need to humanize that witness for the jury. I'll ask questions like, where are you from? Where do you work? What school did you go to? Don't forget to draw the sting. If you have a witness that's sitting on some bombshell that the defense attorney can't wait to bring out in cross-examination, don't give them that opportunity to have some big aha moment. I'll always address that directly and bring that out in my direct examination. And finally, keep the jury engaged during your direct examinations. This can be tough to do. If you got an expert witness on the stand and it's right after lunch and he's talking about the results of a gas chromatograph test, you may have people falling asleep. So figure out a way to keep the jury engaged. For example, with the drug analyst, I have him bring photographs of the gas chromatograph machine. I have him point out stuff, explain how he tested it, maybe tell a few jokes about how it looks like a microwave. Anything that you can do to keep the jury engaged, not falling asleep on you. Now next, we're going to talk about the rules of direct examination. Now there are a ton of rules that apply, and I could do an entire video on that, and I will. But for you, just starting out and learning the foundation of direct examination, focus on what I call the big three. So the big one is leading questions. Leading questions are questions that suggest the answer within the question. Leading questions always draw objections. It makes you look sloppy, and there's a technique that you can use to control the flow and the direction of your direct without asking leading questions, and I'm going to teach you how to do that in just a second. Another big one, during your direct examination, generally speaking, your witnesses are limited to testifying to their sensory observations unless it's an expert witness. But most of the time you're going to be dealing with lay witnesses. So refrain from asking questions of these witnesses that draw opinions. Instead, ask them questions about what they saw, touched, taste, felt, heard. Most importantly, control the direction of your direct. Every witness is different. Some police officers testify very well, others not so much. This is why it's important to meet with your witnesses ahead of time, have your questions ready to see how they're going to answer them. Some will get right to the point and answer the question. Others go on these long tangents. You need to script your direct for your witness in order to keep them on track, so you're concentrating on getting that theory and that story to the jury and not letting your witness take the direct in a direction that it doesn't need to go. A common mistake that I see a lot of lawyers make is they ask what I call the what happened next questions. They'll say, what happened next? Or what did you do next? Where did you go after that? By asking these vague questions, it gives the witness an opportunity to go into an area that's not relevant, something that you hadn't planned for, and it really takes away from your theme and your theory that you're trying to portray to the jury. Instead, you want to ask questions that points the witness in the direction that you want them to go. You're not allowed to ask leading questions, so how do you control the direction of your direct without asking leading questions? It's a technique that's worked for me over the years that I call leading the witness without asking leading questions. Take a look at this example. This is a DWI case where you have a witness on the stand who was at the bar and saw the defendant drinking before he got into his car and drive. So looking at this fact pattern, how can you control the direct of your witness at the bar? Maybe you've met with this witness and they're all over the place, and you ask them a simple question like, what did you hear the defendant say? And they take 3 minutes to answer it and go in the big circles, and they can't focus their answer. Use this technique here. Ask pointed questions of the witness. Did you see the defendant at the bar that night? Notice I didn't say, where were you on the night of January 7th? Instead, I got specific. Did you see the defendant at the bar that night? I want to bring him into the topic that I want to cover, that I have scripted in my direct right now. Once I have him there, I become even more pointed with my questions. Was he at a table or sitting at the bar? Could you tell if he ordered anything? Now notice what I've done here with this question. Was he at a table or sitting at the bar? It's not a leading question. I didn't suggest the answer. I gave two options. I know that he was sitting at the bar, and I know that's what my witness is going to say. It's not a leading question, but I'm keeping him on track to go exactly where I want him to go. Could you tell if he ordered anything? I'm being more specific now, following my script and keeping this direct going in the direction that I need it to go. At this point, my witness has now testified to all the important things that I needed to testify to. But I want to keep hammering my theory and my story in front of the jury. So I say, you testified you saw the defendant almost fall over when he stood up. Now, was that before or after he drank the shots? So look what I did here. I took testimony that the witness had already testified to, and I rephrased it into a question, and then I shaped it into another question. And this is called the looping technique. Looping is a technique where you use the witness's prior testimony to frame your next question. By doing this, you're accomplishing two things. One, you're re-emphasizing key testimony that's consistent with your theory of the case. You're also able to control the flow and the direction of the direct. Let's take a look at some more examples. Now notice in the slide here how the question is framed with the witness's prior testimony. You said you saw the defendant order 2 shots. How fast did he drink them? So my real question is, I want to know how quick the defendant drank the shots before he left and got into his car. But I'm framing it with the witness's prior testimony. It helps me again reiterate important testimony while controlling where I want the direction of this thing to go. And the follow-up questions, I do the same thing. So he drank the shots. How long until he got up to go to the bathroom? That's my question, framed with the prior testimony. And you can really use this as a technique to control exactly where you want to go and keep re-emphasizing key points. Okay, so we've gone over the role of direct. We've covered some rules of direct, and we've covered some techniques. It's time to get the pen and the paper out and write your direct. Script your direct. And I do mean script it in detail, every question. But before you get there, at this point, you should have already reviewed your reports, reviewed video, talked to witnesses, and have an idea of what your theory is going to be, and have an idea of what direction you want these directs to go. If you want some more information on how to develop a theory, check out my other video on how to do a jury trial in 5 steps. I'll leave a link in the description below. Before you get started on writing out your questions in your direct, you have to organize it. There's many different ways of organizing a direct examination. The 2 big ones are topical organization or chronological organization. I'm not a fan of chronological organization. I like using topical organization. I use it in almost every one of my cases. And I like using topical organization because it enables me to place the information that I want in front of the jury in key spots in my direct where I feel it will have the most impact. When you're using chronological order and just kind of going down the line in the story, you start making it boring. You start putting evidence in key things and spots where it's not going to have that impact on the jury the same way it would if you organized your direct by topic. I like to let the jury know right away with the first couple of questions why this witness is there testifying. So I call it getting right to the point. And I'll ask them with the first question, please state your name. Why are you here today? The jurors want to know why you're here. What are you here to testify about? Well, I saw the defendant rob the Dollar General store. Now that the jury knows why this person is here, then I'll jump into what I call the intro or my formalities where I'm going to introduce this person. But don't forget how important it is to humanize your witnesses with the jury. Now that I've introduced my witness to the jury and I've covered the intro, it's time to dive into what's going to be the heart of your direct examination. And this is where it's important that you've developed a theory before you start to write your directs, because the way that you place these topics in there is going to have to relate to whatever you've come up with for your theory and what's going to make it more persuasive to the jury. For me, in a typical case, as I mentioned earlier, I focus on the undisputed facts first, and I get that evidence out in front of the jury right away, right at the beginning. And then I try to elicit some testimony from the witness that makes those disputed facts more likely to have happened. And now that I've established all the important parts of my case, I'm going to switch gears at the back end of my direct exam, and I'm going to attack the defendant's case, and I'm going to draw the sting out of my witness. Almost every witness is going to come with some baggage. Rather than letting the defense attorney have some big gotcha moment on cross-examination, I'm going to bring that out in my direct examination. As we talked about earlier, that technique's called drawing the sting. If you want to see the best example of drawing the sting that I've ever seen, watch the battle scene at the end of the movie from 8 Mile. And finally, when you get to the end of your direct examination, you always want to end strong. You want to leave the jury with something memorable. but make sure that it's admissible. The worst thing you could do is try to bring some hearsay in at the end that sounds cool, but it's never coming into evidence. Makes you look stupid and it screws up your flow. Keep it simple, make it memorable, state it with certainty, and make sure it's consistent with your theme and your theory. So after you've finished your outline, I highly recommend that you sit down and you script out your entire direct and you write out every question and you become very familiar with that script. And you take the time to go back and revise it and make that script as consistent as you can with your theme and your theory of the case. That's it. Thanks for checking out my video. As always, I sincerely hope that this provided some value for you in helping you with your next jury trial. Please visit my website, my Facebook page, or leave me some comments below. If you have any questions at all, please contact me. I'd love to help. We'll see you next time.